They say home is where the heart is, but in my case, it was also where the war began, and did in glorious fashion. All thanks to one woman who thought she could run a neighborhood like a dictatorship, HOA Karen, self-appointed Queen of Crescent Grove Estates. The kind of upscale suburban community that advertised peace and safety, but hid its poison in bylaws and brick facades. I moved there 4 years ago, knowing I could tolerate the HOA politics for a while. But I never expected they'd try to control everything from the length of my grass to the color temperature of my porch lights. When I finally decided to sell my house and move to the quiet wooded property my grandfather left me, just a few miles outside the HOA boundary, I thought I was free, clear, and done with the nonsense, until I got served a court summons by none other than Karen Landon, the so-called president of Crescent Grove HOA, claiming I violated Clause 14.3.1 of the Community Charter, which apparently gave them power to review and approve all post-exit property transitions and future land uses of former HOA members. A clause so absurd it practically disqualified itself, but Karen had attached a fine of $7,500 and accused me of violating a non-compete community clause, whatever that meant. And that's when I realized she wasn't just petty, she was dangerous. She didn't want to run a neighborhood. She wanted to control the lives of everyone who'd ever lived in it. And unfortunately for her, I'm not just a homeowner. I'm a licensed municipal land use attorney with 10 years of experience in real estate zoning, HOA statutes, and corporate housing law. And when I saw that clause, I smelled blood, because while Karen thought she could intimidate me into returning to Crescent Grove or coughing up the fee, I knew something she didn't. Her entire HOA was built on a house of cards, legally operating for over a decade without proper registration with the state's Office of Community Housing Compliance, bypassing regular audits, enforcing bylaws, never approved by the county, and worst of all, collecting dues from residents under a false tax exemption code meant for religious nonprofits. And while most residents were too scared or disorganized to challenge her reign, I was the exact opposite a man with a vendetta, legal knowledge, and documentation gathered over 2 years of watching Karen operate like a suburban warlord. I spent nights digging through county databases, collecting digital copies of formation documents, and interviewing neighbors whose letters of appeal had been ignored or shredded by Karen's committee. And by the time we walked into court, flanked by 2 smug lawyers, she clearly paid with HOA funds. And me walking in solo with a folder full of receipts, I knew this was going to be fast, brutal, and permanent. The judge, a man named Dobbins I'd argued in front of twice before, raised an eyebrow at the ridiculous claim Karen filed, then turned to me for a response. And I calmly handed him a flash drive and printed binder titled Illegality and Misrepresentation of the Crescent Grove HOA, filed by Jacob R. Denton, JD, which outlined 14 major violations, 7 counts of falsified administrative filings, 2 counts of misappropriated funds based on publicly available accounting records, and 3 cases where Karen had extended HOA jurisdiction into non-member properties through forged easement, including Menand, when Judge Dobbins flipped through just the first 15 pages. He slowly removed his glasses, looked at Karen, and said, "Ma'am, if even half of this is true, this is not a civil suit, it's criminal." And her face went from gloating to ghost white as I sat there, completely calm, hands folded, as the courtroom buzzed with tension, and one of her own lawyers whispered something to her before visibly pushing his chair back like he wanted no part in the coming storm. The judge paused, then looked back at me and asked, "Mr. Denton, do you have proof of these claims being submitted to state authorities?" And I smiled as I pulled out a receipt from the state attorney general's office dated 2 days prior, showing I had filed a formal fraud and corruption report against the HOA, accompanied by all evidence now submitted to the court. Judge Dobbins looked back at Karen and said, "This case is dismissed with prejudice, and Ms. Landon, highly suggest you seek legal counsel for what comes next." The courtroom practically gasped as Karen's jaw hung open, stunned, frozen in the realization that the tables had turned so fast she didn't even have time to scream. I walked out of that courtroom without saying a word to her, but the fallout was glorious. Within 5 minutes of that verdict, I forwarded the judge's summary ruling to the county registrar, which triggered an immediate administrative audit. And within the week, Crescent Grove HOA received a cease and desist order from the state, barring them from collecting dues or enforcing any bylaws until their entire organizational structure could be reviewed, which, spoiler alert, it couldn't. B, because the HOA had no legal foundation in the first place. Residents stormed Karen's office demanding answers. People tore down HOA signs from street corners, and by the end of the month, the so-called Crescent Grove Homeowners Association had been fully dissolved by court order, and Karen, well, she was last seen handing out neighborhood watch flyers by herself, like some fallen dictator who refused to admit defeat. While I enjoyed a whiskey on my back porch, watching deer graze by the creek, my land protected, my name cleared, and my neighborhood, finally, mercifully, free.